Indeed, an action day at the Supreme Court in relation to the Akwatia Member of Parliament issues. First of all, two issues came to the fore at the Supreme Court, two separate applications that have been filed by the embattled Member of Parliament for Akwatia. His application asking that an order of interim injunction be placed on the judge, and also a decision, or the Supreme Court quashed the decision for the High Court to impose an interim injunction on him. That was one of the issues that came to the fore. It was argued extensively. Both parties came in. The lawyers, Gary Nimako, who led the applicant, made his submissions to the court. Lawyer for the first interested party, the NDC, Bernard Bediako Bedu, also responded strongly to that. And the lawyer for the Electoral Commission, Justin Amenuvo's point was very simple. The court is a court of record, and so whatever was before the court when that decision was making is what the Supreme Court ought to rely on to make a determination, and that matter was adjourned to April 30. But of course, the issue of interest to many is the issue of the contempt conviction of the Member of Parliament for Akwatia, Ernest Kumi. Well, his request to the court was that the High Court breached the rule of natural justice. He was not given the opportunity to be heard, and the court went ahead to hear the application for contempt in his absence, went ahead to convict him, even when they filed an application to arrest the ruling on that day. But of course, lawyers of the interested party, the NDC parliamentary candidates, Henry Boakye Yiadon, opposed clearly and said at all material time, the applicant was aware, Ernest Kumi was aware of processes, he was served with the processes, and so the High Court did not breach any rule. One issue that came to the fore was the issue of Gazette. At the time that they were making that particular depositions in court, was the Gazette published, and they indicated that the Gazette was public. First, let's hear from the counsel of the interested party, that's the NDC parliamentary candidate.
This is instructive. In fact, that is their case, that it happened without a Gazette notification. Per what is before the Supreme Court, was there a Gazette notification or not? There was. They haven't said that what we exhibited is wrong, or is improper, or is fake. They haven't said that. And so if there is record to show, even if it is today, that the court has come to know that indeed it had been gazetted on the 24th, that ends the matter. Because they are saying that as at 31st we filed the petition, the Electoral Commission had not gazetted the results. If we have record, even today, because jurisdiction could be raised at any time, and so if they are raising it and it turned out that indeed we had the notification done on the 24th, I think that ends the matter.
Gary Nimako clearly also has some views to share in relation to the contention of the issue of Gazette.
Oh, let's wait for the court to determine it. If indeed there was Gazette, why did they ask the court to prohibit Gazette? That's not the question. This was the Gazette. Why did they say the court should prohibit Gazette?
Okay.
As at 2nd of January 2025. So please, let's wait.
It is an interesting scenario at the Supreme Court, but of course the parties will have to wait until the April 30, where the Apex Court, a 5-member panel of the Supreme Court presided over by Justice Gabriel Pwaman, make a determination in relation to the two separate applications. But one that is key is in relation to the contempt conviction in which the applicant, Ernest Kumi, is challenging. But until then, the conversation will still continue as to what will become the fate of him. For now, the interim injunction on the High Court still holds. But what is clear is that the Apex Court of 5, including Justice Professor Henrietta Mensah-Bonsu, Justice Ernest Gawu, Justice Henry Anthony Kofi, and Justice Richard Ejefrimpong, will make that determination. From the Supreme Court of Ghana, Murtala Inusah, GHOne.